I'm Randy Barnett from the Georgetown University Law Center. I was the lawyer for Angel Rach and Diane Monson in the medical marijuana case that came out of California and that was argued in the Supreme Court in 2004. I argued that case. It was decided in 2005. And one of the reasons why that relates to this case is because we had a Commerce Clause challenge that went to the Supreme Court. So I became quite familiar with both the Commerce Clause in the Constitution and the Supreme Court's ruling on the Commerce Clause. And the case, Gonzalez versus Raich, which is the case that came out of, the decision that came out of my case, is the case that's relied upon probably most extensively by supporters of the health insurance mandate. Well, the Attorney Generals of multiple states, I'm actually not sure how many we're up to now because more keep joining, filed a suit objecting to the constitutionality of various aspects of the health insurance bill. I'm sure there are going to be many other lawsuits, including lawsuits on behalf of individuals. It's the joint nature of this Attorney General suit that has seemed to bring it special attention. Right. Well, the issue of the constitutionality of the individual health insurance mandate is something that I raised back in December before the Senate voted on its version of the bill. And this was done in a report that I co-authored for the Heritage Foundation, in which I questioned the constitutionality of that one aspect of the overall health insurance reform. And the nature of the question that we raised revolves around the fact that something like this has never been done before by Congress against individuals using their Commerce Clause power. The Commerce Clause says that Congress shall have power to regulate commerce among the several states. And as broadly as that power has been interpreted, and it has been interpreted very broadly, broadly enough to justify Congress's regulation of the health insurance business, and health insurance is not itself commerce. Given even how broadly it has been interpreted in the past, the Commerce Clause power has never been used to require that individuals enter into a commercial relationship or a contractual relationship with a private company, and in this case it's a health insurance company. So something that's never been done before is unprecedented, and therefore it's not something that the Supreme Court has passed upon, it's not something that they've approved, and I think it's something that they may actually hold unconstitutional. Well, in addition to the fact that something like this has never been done before and the Supreme Court has not passed upon it, there's some good reason to doubt that the power that Congress has over interstate commerce really extends to telling people who are doing nothing at all that they must engage in commercial activity. The power to regulate commerce is the power to make Congress regular, and it has also included the power to prohibit activities that have a substantial effect on interstate commerce. But the idea that Congress could then order people, compel people to engage in economic activity by entering into a commercial relationship is something that would affect the liberties of the people in a very fundamental way. And it's certainly not something consistent with the original meaning of the Constitution. And given the fact that the Supreme Court hasn't authorized anything like this in the past, I think there's good reason to doubt it will extend the power of Congress to reach inactivity and compelling people to engage in economic activity. Yet, this is not really a tax. It's a penalty, which means it's a fine. In fact, the bill labels it a penalty. The President of the United States has denied it was a tax when he was asked about it, because it would violate his no taxes pledge. It is, in fact, he's right, a penalty. And the Constitution distinguishes between taxes and fines. There's a taxation power, but there's also the Eighth Amendment prohibition on excessive fines. So the Constitution knows the difference between a tax and a fine, and the American people know that difference as well. And I also think the court will understand that there's a difference between saying that you have to do something and then fining you for not doing it and use the Internal Revenue Service as your enforcement agent, and raising tax money and then giving tax credits against a general revenue scheme such as we have with the Internal Revenue Service and the income tax. And I think the American people can tell the difference between a penalty and a tax. Imagine, for example, if the first draft during the Civil War was sold as a tax provision. Why? Because people could either serve in the draft or they could pay a flat fee to get out of the draft, which is essentially the way the health insurance mandate is structured in the bill. I don't think anybody thought that the draft, the military draft, which compelled you to enter into military service unless you were willing to pay a fee, was actually a tax, and therefore Congress had the power to do that under its tax power rather than under its power to raise and support armies.